Welcome back to the video lecture on East Asia's cultural influence on the law of the sea. This time, we are going to working on very specific issues of the law of the sea in East Asia and its cultural influence. The world oceans have been a cradle of civilization due to these vast and enigmatic issues, an arena of exploration and a conduit for cultural exchange for a millennia. As maritime society flourished along the shore of East Asia, they cultivate a profound connection with the seas, shaping their collective identity and influencing their approach to governance. The cultural heritage of East Asia, encompassing the philosophical beliefs, ancient maritime traditions, and profound reverence for the natural world, has left an indelible mark on the development and evolution of the law of the sea. The law of the sea, a pivotal framework governing the right and responsibility of nations over the oceanic spaces, has emerged as a reflection of diverse cultural narratives and historical experiences. Within this context, East Asia stands as an exceptional case study where cultural values and traditions have intricately intertwined with modern legal principles, crafting a unique maritime legal landscape. Intricately woven into the cultural fabric of East Asia are historical claims and territorial identity, intertwining narratives that have shaped the region's stance on sovereignty and maritime rights. Maritime territorial dispute, such as the complex and intricate South China Sea dispute, exemplify how cultural ties to the sea intensify the complexities of applying the law of the sea. Cases at the International Tribunal for the Law of the Sea concerning the Philippine and Chinese claim of the South China Sea underscore the interplay of cultural narratives in shaping positions on maritime boundaries. In the modern era, East Asian nations have embraced international legal frameworks, including United Nations Convention on the Law of the Sea, while preserving their cultural perspective on the seas. The delicate balance between adhering to international law and safeguarding cultural interests has been illuminated in international cases at the International Court of Justice and the International Tribunal for the Law of the Sea, which have explored interpretations and applications of UNCLOS in the context of East Asia's rich cultural heritage. This lecture endeavors to illuminate the intricate connections between East Asia's cultural heritage and the evolution of the law of the sea. By exploring international cases, this lecture aimed to unravel the enduring influence of the cultural values, Asian traditions, and philosophical outlook on maritime governance in the region. As the world grapples with the maritime challenges in an ever-changing global landscape, a profound appreciation of East Asia's cultural underpinnings will undoubtedly enrich our understanding of the complex and evolving legal tapestry of the seas. It is commonly recognized that the law of the sea was influenced by European civilization, so-called Eurocentrism. However, the exclusive focus of the Western legal theory on European history largely ignored the developments in India, South Asia, China, and Japan. Hugo Grotius, we call that the father of the international law, who published the Mare Liberum, through which he proclaimed the freedom of the seas. Grotius argued that it is by no doubt that peoples or countries in their outlook and behavior in international relations are affected by their cultures or cultural traditions, which reflect their history, value, habit, and accumulated social and political mores of their societies. Accordingly, it is indisputable that cultures influence each other. It is essential to understand the history, culture, and cultural traditions of the Asian traditions, along with their contribution to the development of modern international law. The question of whether European civilization exclusively shaped international law has been a subject of debate. It is contended that Asian countries have also exerted significant influence on international law, particularly concerning the law of the sea. The 14th and 15th century witnessed a fervent quest for spices in Asia, with particular emphasis on the high demand for aromatic spices from India and East Indies. European countries, notably Spain and Portugal, embarked on maritime expeditions to India in pursuit of collecting and procuring these coveted spices. In the discourse, the surrounding freedom of navigation in the Indian Ocean, Grotius drew attention to the Asian state practice of embracing unrestricted commerce and trade between diverse nations and peoples. This underscored the significance of considering the Asian perspective on freedom of navigation. Grotius further highlights that Asians has long been engaged in unimpaired navigation and peaceful maritime trade in the Indian Ocean, thereby challenging the notion of European dominance in shaping these early principles of international maritime law. Moreover, in the 7th century, the Chinese also influenced the law of the sea through its increased maritime trade between China with other countries such as Egypt, Persia, and India. The seas in East Asia were characterized by the prevailing state of tranquility, with East Asian nations largely enjoy the relative peace at sea, apart from the isolated instances of piracy. In the 15th centuries, maritime shipping and trade in Indian Ocean witnessed a notable upsurge. It was during this period that Malaccan trade reached its peak, and its written the Maritime Code in Malacca came into existence. The written Maritime Code codified commercial and maritime uses and included rules about the rights of the captain of the ship, the sovereign at sea, and other rights obligation on sea. These codified rules, along with practice on the seas, showed that the high seas were also accepted as free. It is contended that, with limited exceptions, Asian nations demonstrate a clear understanding of the principles governing law of the sea. This Asian practice of free navigation of trade, characterized by peaceful conduct, also found the reference in Grotius' doctrine of the freedom of the seas. In the aftermath of the Second World War, the Asian state gradually assumed a more influential role in shaping international law. This lecture aimed to elucidate how East Asia in particular left an indelible imprint on the development of the law of the sea. Thank you very much for your kind attention.